Imagine you and your wife are parents to a beautiful baby girl. For the first 2 years of your daughter's life, you and your wife have shared in the joys and frustrations of being parents. Suddenly, your world shatters. Your wife has passed away. Now, you are grieving and you are parenting by yourself. For reasons you don't understand, you don't fully understand, but social services intervenes and takes your child. You desperately try to get your daughter back. The caseworker speaks to you in English and Spanish. But there's a problem. You don't speak English or Spanish very well. You speak Acateco, an indigenous language of Guatemala. You try to communicate, you try to tell your story, but you can't get past the language barrier that separates you from the caseworker. You try to tell the caseworker, look, she's my child, give her back, I will take care of her. At every turn, you try to participate in the reunification process, but you don't understand, and no one really understands you. The caseworker recommends that your parental rights be terminated because you were limited English proficient, and the court agrees. This story is based on a real case where the caseworker and the court never provided this father with an interpreter who spoke Acateco. They never provided him with vital documents translated into Acateco or with programs or services in Acateco. Ultimately, the Court of Appeals overturned the termination of parental rights, ruling that a parent's limited English proficiency was not a sufficient basis to terminate a parent's rights. Now, I've asked you to imagine yourself as this grieving father, but what if you were the judge or one of the attorneys, the guardian ad litem, or even a colleague? What would you have done? How about this? If you are confronted with a situation like this, pause. Don't make assumptions about what language someone speaks. Ask yourself, can I really assess this person's ability to be a parent if that assessment is done in a language they don't understand? What do I expect someone to get out of a class that I'm requiring that they take if that class is taught in a language they don't know? Ask yourself, do I have an accurate record? Or am I running the risk of uprooting a family and being overturned? Pausing to assess and appropriately deal with a potential barrier such as communication is your civil rights moment, and it can make a significant difference in a parent's ability to keep their child. Not only is it practical, but it's the law. Under Title VI of the Civil Rights Act of 1964, discrimination is prohibited on the basis of race, color, or national origin, which includes language, in programs or activities that receive federal financial assistance. What this means is that under Title VI, we are required to level the field and remove language barriers that could prevent someone from getting services, programs, benefits, or meaningful information. If we don't adhere to these civil rights obligations, can we truly say reasonable efforts have been made? Can we truly say that we have acted in the best interest of the child, or that justice was served? Likewise, a disability should not be an obstacle to a parent's ability to have full and equal opportunity to participate in services, programs, or activities. Imagine now that you are an applicant with a disability and you have applied to a state agency to become a foster adopt parent. You have met the minimum standards to become a foster parent, and you have successfully completed the orientation and pre-service training. Senior officials review your application and they determine that there is not one child in all of foster care that you could safely take care of. Not one child. In this case, the state agency violated Title II of the Americans with Disabilities Act and Section 504 of the Rehabilitation Act when it failed to look at this applicant for who she was to see how she could safely take care of a child. Instead, they made their decision based on speculation and their own stereotypes and assumptions about people with disabilities. In cases like this, if you fail to make an individualized assessment, chances are you will likely fail to make reasonable modifications to a program that would ensure that a parent or a prospective parent with a disability has a full and equal opportunity to participate in programs and raise kids, just like a parent without a disability. Both of these cases show that you cannot have equality of justice if you do not have equal access. The consequences of not protecting a parent's civil rights are grave. Think about it. A parent could lose their child, not because of demonstrated abuse or neglect, but because a language barrier or a disability was allowed to obscure the facts or hinder needed support. Now, the cases I've shared with you, they're not anomalies. They are not outliers. These cases are real and they happen and they have devastating effects on parents and children. But there's good news. The good news is that you are some of the most powerful people in our field. You have the power to pause, to make sure that language and a disability is not a barrier to equal access. Thank you.